You're not going to hear this on the evening news. No flashing headlines, no panel debates, but make no mistake, the Supreme Court just dropped a 9-0 ruling that might tear assault weapon bans to pieces across the country. And here's the twist. The case wasn't even about rifles. It was about Mexico suing American gun companies for cartel violence. Sounds like something out of a legal drama, right? But tucked inside the unanimous decision from both liberal and conservative justices was one line, one sentence that Second Amendment lawyers are now waving like a wrecking ball in courtrooms coast to coast. This wasn't a narrow ruling. This was the entire bench, left and right, slamming the door on $1 billion lawsuit and possibly cracking open a path to strike down every state-level assault weapon ban built on weak foundations and cosmetic nonsense. So what exactly happened? And why are gun control advocates suddenly sweating bullets? Started with one lawsuit and a bold accusation from south of the border. Mexico sued American gun manufacturers, not for something that happened before, but for cartel violence happening over there. Yeah, really. They filed a case in a U.S. court and said companies like Smith & Wesson, Ruger, Colt, Glock, and a whole list of others were somehow responsible for drug cartels getting their hands on guns. Not because the companies broke the law, but because cartels ended up with their products after buying from shady dealers or smuggling them across the border. Mexico didn't stop at pointing fingers. They wanted cash, big time. The suit asked for $10 billion in damages, plus injunction relief, which is legal talk for, we want to force you to change how you sell guns in America. They even floated the idea of imposing new gun control measures right here in the U.S. from another country's courtroom. If that sounds insane, it's because it is. The case made it all the way up to the First Circuit Court of Appeals, where unbelievably, some judges were actually open to letting it go forward. That's when the U.S. Supreme Court stepped in. And this is where things start to get real. The case made it to the Supreme Court, and this time, there were no fireworks, no 5-4 drama, just a clean sweep, 9-0. Every justice, from Kagan to Thomas, agreed Mexico's lawsuit didn't have a leg to stand on. Justice Alina Kagan wrote the main opinion, and right out of the gate she said Mexico failed to show any direct link between the gun makers and cartel crimes. No specific sales, no rogue dealer's name, no evidence that companies like Smith & Wesson or Glock aided or encouraged anything illegal. Just vague blame. They should have done more. That's not enough, not under American law, not by a long shot. Now behind all this is one law you probably heard about, the Protection of Lawful Commerce in Arms Act, or PLCAA. That's the backbone of the ruling. This law basically says if a gun company sells a legal product and someone misuses it later, you can't sue the company for what that criminal did. Seems obvious, right? If someone drives a Ford into a crowd, nobody's suing the dealership, but anti-gun activists, and in this case an entire foreign government, have been trying to tear the protection down for years. The goal? Bleed gun makers dry in court, force them to change their designs, change their marketing, and eventually just stop making certain guns altogether. Mexican lawsuits was the biggest attempt yet. They claim these companies didn't do enough to stop their guns from getting into cartel hands, even though they couldn't name a single illegal sale or direct connection. They just threw accusations at the wall, hoping one would stick, and the Supreme Court wasn't having it. They ruled the PLCAA still stands, that these kinds of vague blame the manufacturer lawsuits aren't allowed. That failure to prevent a crime is not the same as helping commit one. That matters, because if Mexico had won, you could have kissed the U.S. firearms industry goodbye. Gun makers would have been sued into extinction, and it wouldn't have stopped a single cartel shooting. So this wasn't just about rifles or one weird court case. This was a fight for the legal firewall that keeps the entire gun industry from being dragged through courtrooms every time a criminal pulls a trigger. And that firewall held big time. And then came the sentence that shook the walls. Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. Boom! That line wasn't the headline. It wasn't even the point of the case. But there it was, printed, signed, unanimous, and now it's lighting up courtrooms across the country. Because here's the deal. Under past rulings like Heller and Bruin, if a firearm is in common use for lawful purposes, the government can't ban it, period. And now the Supreme Court just said plainly AR-15s fall into that category. Not fringe, not unusual, not scary, weapons of war. Common, legal, protected. That one sentence is gold for Second Amendment attorneys. It gives them something solid, something binding, and they're already swinging it like a hammer. Those 8 words, widely legal and commonly owned by law-abiding citizens, weren't just a feel-good throwaway. They were a judicial stick of dynamite. And guess where it landed? Right in the middle of California's legal minefield. Miller versus Bont, a case that's been simmering for years, waiting for just the right spark. Well, there it was. Miller versus Bont is no small skirmish. It's the frontline battle against one of the most aggressive assault weapon bans in the country. But here's the kicker. California's law doesn't ban rifles based on function. Nope, it bans them based on furniture, pistol grips, telescoping stocks, flash hiders, cosmetic features, the kind of stuff that makes a rifle look scary to someone who's never held one. That means 2 rifles, mechanically identical, can be treated completely different under the law. At a vertical grip, you're a felon. Leave it plain Jane? Totally fine. And that absurdity didn't sit well with federal judge Roger Benitez. He already ruled the ban unconstitutional once before, slamming it for outlawing firearms that are clearly in common use. His ruling was a thunderclap, but California appealed and the case had been buried in the Ninth Circuit's slow-moving machinery ever since. But now, the Supreme Court bombshell just cracked the case wide open. The plaintiffs wasted no time. In bold, underlined ink, they pointed directly to the Smith & Wesson versus Mexico ruling. That single, unanimous sentence signed by every justice from Kagan to Thomas is now Exhibit A in their argument. And it doesn't whisper, it roars. They're not just arguing these rifles are lawful. They're saying the highest court in the land has already confirmed it. The AR-15s and similar rifles aren't fringe or dangerous anomalies. They're common, legal, and constitutionally protected. Not maybe, not someday, right now. And that's what makes this moment so explosive, because if that line holds weight, and it will, then California laws isn't just flawed, it's on the brink of total collapse. And with it, the whole legal theory that scary looking equals illegal. This isn't just a courtroom filing. It's a direct hit on every gun law in America built on cosmetic, fear, and fiction. And the cracks are starting to show. But of course, not everyone's playing fair. Over in the Ninth Circuit, some judges don't seem too interested in what the Supreme Court actually said. During oral arguments, Miller versus Bont, the panel gave off the vibe of a group trying to pretend that common use doesn't mean what it clearly means. One judge flat out referred to AR-15s as machine guns. Another called them A-15s. Which, yeah, not a great sign when you're deciding whether people can legally own them. Basic facts, apparently optional. Then came the creative logic. Maybe, just maybe, a gun could be common in America, but not in California. So the state can ban it anyway. That's not legal interpretation, that's legal gymnastics. The Constitution doesn't shift based on zip code. But that's the move. Stall, confuse, delay, keep kicking the can until another court saves the ban. And when they can't stall, they try to redefine the law until it barely resembles what the Supreme Court actually wrote. Thing is, that only works for so long, because now they're up against a 9-0 ruling that left zero room for spin. California is not the only one on thin ice. The Supreme Court line, it's already showing up in lawsuits across the country, and not quietly. Gun rights lawyers in Illinois, New York, New Jersey, and beyond are throwing it into filings like a legal hand grenade, and it's hitting hard. Illinois passed its rifle ban in 2023. Millions of gun owners affected. The state told everyone to register their now illegal rifles. You know how many did? Almost none. People didn't buy it, and they still don't. New York, same deal. After Sandy Hook, they rolled out the SAFE Act. More bans, more restrictions, but when it came time to register, crickets. Most gun owners upstate just didn't comply, and the state knows it. So here's why this matters. If you're sitting at home thinking, well, that's just California, think again. The logic behind those bans, the one that says a pistol grip or flash hider turns a legal rifle into a felony, that same logic is used in nearly a dozen states. And now, for the first time, the Supreme Court has called it out without even trying to. This isn't just legal background noise. This affects whether your rifle is a right or a crime, and every court that touches this next is going to have to answer one simple question. Are they following the Constitution or fighting it? So now we've got a 9-0 ruling. Every justice, left, right, center, just told the country AR-15s are legal, common, and protected. That's not an option. That's the highest court in the land putting it in writing. And yet there are still states acting like they didn't hear it. Still trying to push bans, enforce registries, and treat law-abiding citizens like criminals over features on a rifle, pistol grips, flash hiders, folding stocks. The message from the Supreme Court was clear. The Second Amendment doesn't vanish based on cosmetics or zip code or political mood. So here's the real question. Is your state still pretending otherwise? Because if you live in California, New York, Illinois, New Jersey, or even states watching quietly from the sidelines, this ruling hits home. These court battles, they're not someone else's problem. They're yours. Let me know what you're seeing where you live. Are bans being challenged? Are politicians pushing harder? Drop it in the comments. I want to hear from every corner of the country, because the more they ignore the court, the louder we need to be. Hit that like button, subscribe if you haven't already, and stay ready. The fight isn't over, but it just tilted in your favor.